right. Good afternoon.
Good afternoon. May it please the court, Alex Little on behalf of all the appellants. I'll be the single attorney arguing on behalf of the
Apologies. Tell me your last name again.
Little,
Little.
like small.
Okay, because I
Yes.
don't see it on the docket, but nice to meet you, Mr. Little.
Yeah, same. I'd request 5 minutes for rebuttal.
5 minutes, yes, sir.
When the General Assembly passed the Tennessee Public Protection Act in section TCA 2017-109, it specifically called it an additional substantive remedy. The purpose of that remedy was to protect individuals' ability to participate in public life in 3 ways: free speech, assembly, and the right to petition. Here, all of the defendants in the underlying case were exercising those rights, at least as to speech, when the plaintiff in that case, Mr. Solomon, sought an unconstitutional prior restraint on their speech. It's not a close call that the prior restraint that he sought, first ex parte and then through a preliminary injunction, violated their First Amendment rights. And he supported it with hundreds of pages of affidavits, documents, legal arguments that all of these individuals had to respond to in the court below. And they did through, in other ways, filing a Tennessee Public Protection Act petition. Now, before that petition could be adjudicated, after it was litigated, he did defend it, and he filed, again, hundreds of pages in defense. He eventually ran away from that petition and moved to dismiss it. The same day, he filed the very same case with the very same unconstitutional preliminary injunction in federal court. That case has since been dismissed, as the court has found the federal court does not have jurisdiction. But when the defendants tried to effectuate the substantive remedies that the General Assembly has provided through this statute, the court below said, nope, they moved to dismiss, and you've got an absolute right to do that, and so I'm going to let them go on their merry way. The result for my clients, 2 of whom are 18-year-old college students, 2 of whom are their parents, and 1 is a pro se defendant below, it meant they had to hire a lawyer and spend a ton of money to defend against these claims, which eventually the plaintiff himself walked away from. Now, as it stands, if that plaintiff wants to rebring this lawsuit with the same unconstitutional prior restraint through a preliminary injunction, he can do so. And they'll have to hire a lawyer again who will be very reluctant to take that case, knowing that as soon as it actually gets to be litigated, the plaintiff can again move to dismiss, non-suit, walk away, and they'll be stuck with all the legal bills. The General Assembly, on a bipartisan and really overwhelming fashion, passed the Tennessee Public Protection Act to stop exactly this sort of abuse. And it did so based on a history where you could do these sorts of things. In his brief, the defendant, or the plaintiff, the appellee here, repeatedly says, look, I've got an absolute right to do this. I can file repeated frivolous lawsuits, and as long as I dismiss them, nothing can be done. And historically, that may have been true. But that is exactly what pushed the General Assembly to pass the TPPA. It is exactly what has pushed more than 30 states to enact similar statutes. The TPPA is incredibly different when it comes to civil procedure. I'll admit it's different in many ways. It stays discovery. It allows for adjudications of fact and factual determinations at a preliminary stage that were well outside the scope of Rule 12. And it ultimately allows the defending party to recoup all their costs and fees. And all of those features are important, and they're there for a purpose. They're there to stop individuals from doing what Aaron Solomon has done here. I'm happy to talk about any of the questions you may have. I think we've laid out our position fairly broadly in our brief, but I'll raise sort of the 2 main points. First, and most importantly, the legislative intent of this statute makes clear that that this is the sort of law that Rule 41 is intended to defer to. Rule 41 of the Civil Rules of Procedure, and I think it's Rule 41, I apologize, I'm doing most of this off memory.
It is, but the statute doesn't mention Rule 41, though.
It doesn't. It does mention, however, the rules of civil procedure in Section 109, and it says this is a supplement to those rules.
Yeah, which suggests to me that the lack of a specific reference is significant.
Your Honor, I think that it would be difficult for them to imagine the scenario that we are presented with here.
Well, if the TPPA is intended to address exactly this type of scenario, I would think that would be something they would be well aware as a potential problem is someone could be a serial filer and want to address that.
I guess the problem, Your Honor, with that idea is then they've created a hole which eats the rest of the statute. I mean, I think that the reality is if they had perceived this problem and they said, we're not going to address it, and we recognize that this is going to allow, for example, the attorney's fees provision to be completely eviscerated. There's litigation here, I think it was recently decided, where hundreds of thousands of dollars in a corporate TPPA suit, where if the plaintiff there had walked away, they ended up losing that. I'm sure it'll go up to the Court of Appeals soon. If the plaintiff there decided to walk away at the last minute, they would have burdened the other side with $500,000 in legal fees that, again, could never be recouped in what was ultimately found to be a frivolous and unconstitutional attack on that defendant's First Amendment rights. And so it would be an odd way to structure the statute to provide remedies that then can be sort of evaded through the idea that plaintiffs have an absolute right to walk away from their case at any point.
Is it possible here that maybe this only deals with evading one type of remedy? And I'm thinking about your second point here on the vested interest approach to the problem. If there's a vested interest, if Rule 41 still allows an unfettered ability to non-suit without prejudice, except in the enumerated provisions in the statute, or excuse me, the rule, perhaps you can still do that, and the only thing you lose under the TPPA is just maybe the ability to get the dismissal with prejudice. In other words, you still can get your attorney's fees and costs. Is that the way it would work with the vested interest?
I think it can, and I think that's one of the things we've argued here. What's a little bit unique about this case is the petition was filed specifically as to the injunction and not as to the underlying complaint. And I think that's an important thing that really hasn't been sussed out very much in the brief, because the petition itself attacked the unconstitutional prior restraint that was sought through the preliminary injunction. And so the preliminary injunction is its own sort of legal cause of action. The TPPA makes clear that it need not be a cause of action. It can be any sort of legal remedy that's being sought against you as the defendant. And so to the extent that that is sort of dismissed, it does it carries the sort of consequences that you said. If it's gone, it doesn't have the same sort of impact so long as they can recoup those attorney's fees. And I think we know, for example, that some of the rights that are in the TPPA can't be eviscerated. The plaintiff here has never argued that this court doesn't have jurisdiction. And under the terms of the statute, it's clear that we filed a petition. The court did not dismiss the cause of action or the injunction based on that. And so we had a right to take that up on appeal. So clearly that survived. And it doesn't mean those other provisions wouldn't survive as well in the sort of fashion that you're talking. But I do think to imagine that you could artfully sort of evade this up to the moment the court renders an oral judgment. The court could say things, if we had gone to the hearing that said, I really have concerns about this the way you've done this, and I don't think your cause of action has remedies. And if they've got a piece of paper ready to go to the clerk's office and they drop it, under the current defendant's view of the case, they're allowed to do that. And that just seems to fly directly in the face of what the General Assembly is trying to do here, which is to protect litigants from abusive litigation. Now remember, we'd still have to go back and prove, if this is remanded, if we went on appeal, that ultimately there was a defense or a constitutional remedy or a constitutional defense or another sort of infirmity to his preliminary injunction request.
And it's just the injunctive relief that you're attacking.
It was originally, yes, as unconstitutional. And if you look at the record, this is not a two-page injunction. They ran into court with hundreds of pages of legal argument, briefing.
I've looked at the technical record.
Yeah,
this is on a non-suit. This is a really long technical record.
And so what that means, frankly, is that we're talking about two high school students who are hiring an attorney who knows that there's a provision in the TPPA to recover fees. Without that ability, are those 18-year-olds going to have their rights protected the next time if this court rules the way that the plaintiff seeks, is going to run into court to protect them against an unconstitutional preliminary injunction? It's going to be very, very hard to imagine that's true, no matter how many good-hearted public interest lawyers there are. And I think that is at the heart of what the General Assembly was trying to do. And ultimately, we'd have to prove that. We'd have to go back. We'd have to prove that it failed the elements of 106 or 104, that it fit within the category of actions to be dismissed. And if we do so, I think we're then entitled to the remedies. But the way that the court evaded even deciding the question is, to me, problematic, which
Is the TPPA model over on any specific other states' statute?
Your Honor, I think if you look at both the law review article that was written by sort of the drafters and then the legislative history, I think we cite Senator Dickerson some. By the time that Tennessee has done it, there had been about 27. I think there's now 30. The closest model would have been California. We drew some. I'm barred both places, so I can tell you that there are some intricacies in their civil procedure that we don't really have here. But it does borrow many of the mechanisms from those other states. The mechanism of stay in discovery.
And California is one of those states where this wouldn't be permissible.
That's correct. You could dismiss your case, but you would not be able to dismiss the underlying petition for fees and dismissal. That's correct.
Well, in California, it would work such that you could dismiss, but the dismissal would be conditioned on it being with prejudice.
That's correct. And you'd still be subject to the attorney's fees as well, which the court would then adjudicate afterwards.
Mr. Little, before you sit down,
Yes, sir.
I was incorrect a moment ago when I said you weren't listed on the docket as counsel. I was looking at the second case, which is continued.
disappeared.
So you're very much off record.
Good. I want to make sure I'm officially there. I
You
appreciate
are
it.
official.
If you don't have any questions, I'll save my rest for rebuttal.
Thank you, sir. We'll hear from the appellee. Good afternoon.
Good afternoon, Your Honors, and may it please the Court. My name is Margaret Dodson. I'm here with my colleague Paige Mills, and my firm represents the appellee, Mr. Aaron Solomon, in this case. Your Honors, this case presents a very narrow legal issue on appeal, whether Mr. Solomon is permitted to voluntarily dismiss his case when appellant's anti-SLAPP petition is pending. And the trial court got it right. It held Mr. Solomon was well within his rights to non-suit despite that pending petition, and the trial court's opinion should be affirmed on appeal for three primary reasons. First, in combination with the TPPA, Your Honors, Rule 41 grants plaintiffs a free and unrestricted, that is language from our Tennessee Supreme Court, a free and unrestricted right to non-suit except in very specific circumstances not present here. Courts across this state have affirmed and reaffirmed this right for decades, and this court should not take this case to disturb that established policy in our state. As Your Honors are aware, you can take a non-suit up until a jury retires. This case had been pending for 5 weeks, and it's not an occasion to disturb that rule.
But you got a free and unfettered right to non-suit, but you don't necessarily that will not always result in a non-suit without prejudice, right? I mean, you can, on occasions, if you've non-suited before, for instance, twice before, the third non-suit, yeah, you got a free unfettered one, but it's with prejudice. That's it. You're done.
That's certainly true, Your Honor. That's, of course, not the case here. This was Mr. Solomon's first non-suit. And as you alluded to before, the statute here, the TPPA, does not prohibit a non-suit without prejudice.
Well, I mean, I guess my point is the context in which the non-suit is taken is important. And the context here specifically is you had a TPPA petition facing you when the non-suit was taken.
Certainly, Your Honor. But as this court has repeatedly held and recognized, Rule 41 does allow for an unfettered and absolute right to non-suit, except as Rule 41 states under Rules 23 and Rule 66, which we know are not present here, or under, quote, any statute, which this court has held in Clark v. Werther, which you authored, and which I plan to talk a little bit more about, unless the statute explicitly prohibits that non-suit, which this statute doesn't, or that there is some vested right that has accrued during the pendency of the litigation, which is just not at issue here, Your Honor. The appellants claim they have a vested right for the court to hear their petition or for the possibility of attorney's fees or the possibility of dismissal with prejudice. But at the end of the day, Your Honor, those rights are not accrued rights that are presently enforceable, which is what our Supreme Court has defined as a vested right in Tennessee that would prohibit a non-suit. So absent those circumstances, Your Honor, which are just not present here, there is no right, the plaintiff has an unfettered and absolute right, as our Supreme Court, as our Court of Appeals has recognized, to non-suit.
And so, I mean, So really there is a way to game the system to avoid the effects of the PPA by just taking non-suits, at least a couple.
I would say no, Your Honor, and for a couple of reasons. First of all, this right to non-suit, again, this court has affirmed and reaffirmed time and again that being subjected to a second lawsuit or the reason behind non-suiting is really immaterial, that the plaintiff's right to non-suit is absolute, and it's really not the court's job to look behind the reasoning of that. So just as a matter of law, sort of making that inquiry is really inappropriate, even though appellants, of course, focus on it. And secondly here, Your Honor, in terms of the question of gaming the system, I would submit that is absolutely not what is happening here and not what is before the court. It's actually counterfactual. Mr. Solomon has filed a 57-page response in opposition to the petition. He's filed hundreds of pages of exhibits. He's filed multiple third-party affidavits. This is not a situation where Mr. Solomon has made some frivolous claim and is trying to just see if the defendants would know about the anti-SLAPP statute. There's a robust record here, and we certainly believe that if the petition were heard, that we would have been successful. So while the TPPA certainly does have one aim of recognizing free speech, that's not the only policy consideration that's at issue in this appeal.
I notice you really didn't engage with the argument that the appellants are making here that, look at the other anti-SLAPP statutes from other states. Is that because Tennessee's conception of a voluntary dismissal is so different from those states? Well,
Your Honor, those states are certainly not binding on Tennessee. The cases that the appellants cited all talked about substantive remedies or rights. They don't talk about the vested right, which is, I believe, the point that they were really trying to make in terms of analogizing to those statutes. I also just want to point out California, which came up earlier. To my knowledge, Your Honor, California doesn't have that key language that our TPPA has, which states that the TPPA is not intended to interfere with any other right of any party to assert any other privilege. That's obviously a key part of our argument, that the TPPA expressly states that it doesn't interfere with any right of any other party, which would naturally include Mr. Solomon's right to non-suit, and that's a really critical piece of the TPPA here. Not only does it not, as Your Honor has held in Clark v. Werther, expressly state that there's some prohibition, but it actually goes the opposite way to say this statute doesn't at all impact the right of any party to assert a remedy or defense or privilege that's entitled to it under the law. And so, Your Honor, just to talk a little bit more about the TPPA and its language, and I do just want to quote, as I said, the language of that statute is really clear, and it really belies any argument by the appellants that there's some express or implicit prohibition on statutes, on non-suits. Instead, it says, as I alluded to earlier, it does not affect, preclude, or limit the right of any party to assert any defense, remedy, immunity, or privilege otherwise authorized by law. So, Your Honors, here, the TPPA is really very clear. It and any pending petitions brought under it are not intended to deprive litigants like Mr. Solomon of his otherwise free and unrestricted right to non-suit. And that's really fatal to appellant's claims. As I've talked about and alluded to Clark v. Werther, this court has already held that in order to prohibit a non-suit under the, quote, any statute language of Rule 41, that prohibition must be expressly stated. The court wrote, and I'm going to quote you, Judge McBrayer, that the reference to any statute
It may be a huge mistake. I'll just tell you right now.
Let's hope not. Is part of a list which includes Rules 2305, 2306, and 66. Each of the listed rules expressly limits a party's right to take a voluntary non-suit in certain types of cases. And going on and applying the well-known statutory canon of adjustum generis, the court held that, quote, of any statute must refer to statutes that specifically limit a party's right to obtain a voluntary non-suit. Nowhere, Your Honors, nowhere does the TPPA contain any such express prohibition. So on this first point, the same reasoning as applied in Clark should control here, and as the language in the TPPA really in no way prohibits Mr. Solomon's absolute right to non-suit.
Did I hear you correctly? I think you argued that Mr. Solomon would be able to successfully defend against the petition filed here. Is that what you said?
Yes, Your Honor, that's certainly our position.
Yeah. Is that because your argument is that the speech involved here is not protected by the TPPA?
Absolutely, Your Honor. And that's one of those other policy considerations that I was talking about. While the TPPA is certainly enacted to protect constitutionally permissible speech, it only goes so far. It's not enacted to protect, otherwise illegal speech. And one of the dual aims, as stated by the legislature and as recognized by this court, is to continue to provide those who have been damaged by illegal or otherwise harmful speech to bring meritorious claims with demonstrable injury. And that's what we're talking about here. It's not, as I said, a case where there is no record as to the plaintiff's argument or position on that. There is actually a very robust record that Mr. Solomon has filed, and we certainly believe that that petition would be adjudicated in our favor, in which case we could be entitled to our fees, which just shows that there really isn't any vested right of the appellants in what they're claiming that the legislature had provided for them in filing their petition.
Let me ask you about something our Supreme Court did last month. They vacated one of our judgments in Adamson against Grove. That involved a sort of similar factual situation. You had a lawsuit, plaintiff dismissed, non-suit, but there was a pending anti-SLAPP petition there. And in that case, the petitioners of the anti-SLAPP successfully got the trial judge to alter or amend the dismissal to make it with prejudice. We had dismissed that appeal, and then the Supreme Court said, no, that was improper for us to dismiss it because of a technical error in the notice of appeal. But to me, it seems somewhat noteworthy that the Supreme Court did not take that opportunity to say something to the effect of, there's no real issue here because Mr. Adamson should have had an outright right to non-suit his case. I mean, that would have taken care of that issue entirely. Can we read anything into the Supreme Court's action last month, or does that matter?
Your Honor, I would, without being familiar with the Edmondson case, aside from what you just provided.
Adamson, I think.
Oh, sorry,
Adamson.
Edmondson.
Yeah.
Excuse me.
It's out of Sumner County.
Okay.
It was last month.
My apologies. Without being familiar with that case, I would say no. Here, there has not been some sort of motion for reconsideration in terms of dismissal with prejudice that would have.
The procedure there makes the difference.
Absolutely, Your Honor, and unless there is some language that you haven't told me about, it doesn't sound like the Supreme Court really opined one way or another on the Rule 41 and the interaction with the TPPA. They did not.
The order was issued just on April 14th.
Very good. Thank you, sir. I also do just want to talk a little bit more about this vested rights issue that the appellants make on appeal. And of course, there is no question, Your Honors, that the TPPA does grant successful petitioners a right to fees. It grants successful petitioners a right to dismissal, but it doesn't grant all petitioners with those rights. There has to actually be a decision on the merits of the petition for those rights to be enforceable. And in a case where, if you've reviewed the technical record, you are familiar, the parties can't really agree on just about anything. We can agree that the petition was pending at the time of the non-suit, and that those rights, it had not been fully adjudicated, and that those rights have thus not been vested. And for that reason, as the trial court correctly noted, their appellants are really in the same position as a defendant who's filed a Rule 12 motion to dismiss, and as this court is well aware, Tennessee permits successful defendants who are successful on a Rule 12 motion to their fees, but of course they have to be successful. And there's no question in Tennessee that a plaintiff can take a non-suit under the Tennessee rules while a Rule 12 motion is pending, and the plaintiff doesn't then have to go pay the defendant's attorney's fees just because they filed that motion. And the same principles apply here. And that's really why we're here, Your Honor. The appellants want their fees, they want dismissal with prejudice, and they just don't have a right to them as a matter of law. They had a contingent or a possible right, but at the end of the day, those contingent rights are just not vested. I do just want to very, very briefly address this argument that even if Mr. Solomon was within his right to non-suit, that somehow the petition survives. As Your Honors are well aware, Rule 41 does provide that if there's a counterclaim pending, that can remain even in the instance of a non-suit. That is not the case before the court. The TPPA is, I actually don't know if it could be clearer. It says nothing in this chapter creates a private right of action. Nothing in this chapter allows a petitioner to bring a claim that would somehow,
So therefore, it can't be deemed to be a counterclaim.
Exactly, Your Honor. And in addition, as Mr. Little already alluded to, this petition was actually filed in response to a motion. It wasn't filed in response to dismissing an entire case. It was procedurally filed in response to the motion for preliminary injunction, and practically, as the trial court noted in a well-reasoned opinion, it couldn't start a legal action. It doesn't state a basis for jurisdiction, and therefore can't be allowed to continue one. So I see my time is up, but we do certainly ask that this court affirm the opinion of the trial court and its holding that Mr. Solomon was within his rights to non-suit the entire action. Thank you, Your Honors.
Thank you, Ms. Dotson. And Mr. Little, your time for rebuttal.
I'll try to hit all these as quickly as I can. One factual matter about the record. We did ask the court below to make sure that the dismissal was with prejudice. First thing in the record, as you'll see in the technical record, they filed the leave for non-suit. We said, no, if you do it, it's got to be with prejudice. So we did do exactly the same thing. The Adamson court saw it, except we did not get the court to do it. So procedurally, that did happen. A few things. Why are we here on appeal? We're here on appeal because the General Assembly said specifically that a refusal to dismiss on a TPPA grants immediate appellate rights. Does that mean that everybody who gets non-suited in this sort of case when there's a TPPA pending just has an appeal to come up here and say hello to you all? We love being here, but that doesn't make much sense. What that presumes is that there's a decision on the merits, that the court has considered the petition before it. Because without an appeal, there's nothing for this court to decide. But it's very clear from the language for the appellate right that this court has to decide something, that it has to decide whether that refusal was on solid grounds, and whether that refusal sort of fit the petition's, fit the contours of the statute, which here means that the petition has shown that the defendant did not have, that the defendant had either a legal defense or the plaintiff did not make a prima facie case based on affidavits. So that's an issue as well. The respect of whether it's a counterclaim or not, I think it's important to point out here that you can have types of claims that are not necessarily private rights of actions. There are remedies. There's a whole law, a whole course in law school about remedies that are divorced from private rights of action. We don't claim and have never claimed that we could have started a case or could file a case tomorrow under the TPPA. If somebody filed a lawsuit, dismissed it after a week, we have 60 days to file a TPPA action. We're not claiming that. But once you're in the course of a lawsuit and the TPPA petition is filed, we do believe it creates a type of counterclaim which would stop the complete dismissal, the dismissal that they say they have absolute right to from adjudicating everything in the case. And this case demonstrates why that's so pernicious to be able to allow a counterclaim of their claim, which there's reasons to allow plaintiffs to control their case. But there's not a reason to allow the plaintiff's control of the case to defeat other rights that statute says that the other party has. And here, those are pretty clear. This case that the appellees rely upon is from 1976. And I'm not doubting that there's a great bit of discretion to Rule 41. But the entire purpose, if this court spends time looking at the legislative intent and the structure of the TPPA and the history of these statutes across the country, the entire purpose of these statutes is to rein in the sort of indiscriminate use of litigation as a tactic of abuse. And that's exactly what's happened here. And I don't think there's any doubt the General Assembly could point to this case as an example. When they tell you somehow that no, we're not trying to game the system, they walked the same day into federal court. And they walked into federal court because there's no ability to bring a TPPA claim there. And when they tell you that they can defend this case, the district court who heard that didn't even set a hearing on the preliminary injunction for months and months and months, and then ruled in our favor on the motion to dismiss. Nothing about the way they've litigated this case is consistent with what they just told you, that they could defend their TPPA petition. They're here because this was their only option to get away from paying attorney's fees and for bringing a suit that violated my client's First Amendment rights. It was maybe we can go to the Court of Appeals, get the district court, get the Chancery Court judge and the Court of Appeals to agree that we can get away with doing this. And that flies in the face of the first section of the TPPA.
So was Clark against Werther decided incorrectly then?
Are we talking about the 1976 case about Rule 41?
The 2016 case.
Oh, well, I think that's still relying back on...
They placed the interpretation of Rule 41 that said the language to the effect of or otherwise provided statute has to have a statute that explicitly says non-suit's not available.
No, Your Honor, I don't think it's decided incorrectly. But I do think when you look at 41, the provisions of whether there's a vested right fit firmly into TPPA land. And so here, there are other aspects of Rule 41 that would demonstrate that you can't extinguish our claim for the TPPA rights that are notified in the statute. I think they're different things. The plaintiff's ability to control their lawsuit may be absolute, but the plaintiff's ability to then use that as it can't be both a sword and a shield. And here we're saying, don't let them use it as a sword to eviscerate the rights of these defendants below. If you have any questions, I think that's my time.
Thank you,
Thank you.
Mr. Little and Ms. Dotson, for your arguments. You have given us a lot to think about, so we'll do our best. That concludes the afternoon docket.
All rise. This court stands adjourned.